Good afternoon. Thanks for tuning into our webinar today. My name is Jeff McKay from Brightsquid. I'll be sort of steering us through the presentation, but before we do get started, I'm going to turn things over to Parker from the association to say a few words. Hey, Parker.
Good afternoon, and thank you, Jeff, and thank you all. My name is Parker Hogan. I'm the Director of Member and External Relations with the Alberta College and Association of Chiropractors. Pleased to have the folks from Brightsquid here today to give all of you an overview and help you understand the different privacy compliance issues and obligations that you all have as regulated health professionals under the Health Information Act, as well as under the HPA. This is what we understand going to be a larger area that the government will be examining and looking at in the future to ensure that all health professionals are making the confidentiality and the safekeeping of patient information and records. And in light of the expansion that we've seen in things like telehealth and virtual healthcare and some of those other issues, this is something that is both timely and important. So there will be a quick survey afterwards. Please let us know what you think and if you need more information. And with that, I will turn it over to our learned counsel.
Awesome. Great. Thanks so much, Parker. Actually, before we do get started and launch into it, just want to get a baseline of how everybody feels about privacy. So I'm going to launch a quick poll question here. It'll pop up on your screen. So just, kind of pick an answer. One is the lowest. How would you rate your clinic's level of privacy compliance? 5 is we've got everything buttoned down and we're super confident that everything we're doing is safe and compliant. So we'll take a couple minutes to get that, or a couple seconds just to let people fill that out, and just to get a baseline where we're at as we go through. And of course, we'll rewrite the presentation in the background based on the responses. So as we go through this, we are going to take you through a lot of the regulations, what they are, what they say, what they mean to you. We'll talk about some of the risks and threats, how breaches come about, and really who's responsible for what. So that's what we're going to dig into. So now we've got, I'm going to give 5 more seconds here to vote. We've got almost everybody in. We'll give it a couple more seconds, but it looks like we've got some good answers. So I'm going to say that's enough. And so just for everybody's point of view, we've got pretty good confidence that we're all compliant with regulations. So as we'll see, you'll see that means that everybody here has a privacy impact assessment. You're handling patient information. All your vendors are handling patient information in accordance with the Health Information Act. And we're going to take you through a lot of what that means. And then we'll ask this question again at the end. So we've got a high level of confidence in our compliance right now, and let's see if we can maintain that through this presentation. So today we're going to go through this with Rohit Joshi, who's the CEO of Brightsquid, who's a lawyer with a background in privacy compliance and communication. Rohit's been doing this kind of thing for longer than I've been alive. That's not true, but for a few decades now. And Ingrid Rice, who's with us as our Chief Privacy Officer. Ingrid's been working in privacy compliance in Alberta and Canada and internationally for a few decades as well. So Ingrid helped run the POS program, which helped get the medical clinics in the province up to speed and launched into EMRs. And together they run our privacy team. So the Brightsquid privacy team is, I think there's now 5 or 6 people on the team who help clinics with privacy compliance, from running PIAs to answering questions about it. We've written a couple thousand PIAs. We've trained over 2,500 healthcare professionals, and we are accredited. And the team is regularly doing ongoing continuing education to stay on top of the new regulations as they change, as you'll see, and to make sure that we're interpreting things as they are being interpreted today. So with that, welcome Rohit and Ingrid.
Thank you.
Thanks for joining us today. So the agenda we're going to talk about today, what we're going to go through, we're going to talk about the legislation. So what are the acts that you fall under? Where do you go to find out what the rules are for you? We're going to talk about what compliance means. We're going to look at some of the privacy principles, or the privacy principles, in terms of how you can measure what you're doing in your clinic. We're going to talk about how the Information Act, which is the major legislation, how that applies to different people in your clinic, how they're categorized. We're going to talk about what a privacy impact assessment is, which is really kind of the cornerstone of your privacy compliance program in your clinic. We're going to talk about breaches, what they are, how they happen, and we'll talk about cyber threats in healthcare, which unfortunately, in the new realities of the world and in COVID-19, cyber threats have become a significant risk to clinics because there are people in the world who like to take advantage of bad situations for other people, and that's kind of the state of things right now. And then we'll talk more about some clinic safeguards. We'll get through them as we go through, but we'll delve into. So I'm probably going to be disappearing from your screen and muting for most of this, and Rhoda and Ingrid are going to be the real contributors here. Before we do get started, we did collect a number of questions before through the registration process. If you have questions that pop up throughout, you are on mute. But there is a question panel in your GoToWebinar control panel on the right of your screen where you can type in questions as they occur to you as we go through this. And we'll try to get to as many of them as we can at the end of the presentation. So without further ado, let's jump in here.
All right, so I don't know if I have permission to start, but if not, too late, I already have. So, so an introduction to privacy, of course, it is a whole new world. We've got countless acronyms that I'm sure have been thrown at you time and time again. Health Information Act, PIA, a Privacy Impact Assessment. It's also known by other terms, custodian and affiliate. It's you. You're the custodian or an affiliate, no matter which way you cut it. PIA, PIPA, of course, PIPEDA. All of these will kind of be explained as we walk through this. So what is health information? This is my favorite part, and I've got jokes to go with it, which may be out of line, so I'll just start with just the story. So health information is diagnostic treatment and care. Duh, that's kind of obvious, right? It's information regarding your physical or mental health. So that's a given. So this information, though, also could include your health provider information. So that's all wonderful. We know that's diagnostic treatment and care, fairly straightforward. We also have registration information, right? The information about the individual, like the demographics, your location, your address, your health services eligibility. So that in itself is registration information or personal information. So health information really is the marriage of the two. So diagnostic treatment and care, so let's say probably not a good example, but a vasectomy clinic. And then when you combine it with a name like Tyler Shandro or maybe Jason Kenny, okay, probably inappropriate statements, but that then forms health information because you've now married a diagnostic treatment and care information with the registration information.
Ingrid, can I just add one thing here before we go on? And by the way, folks, you'll get used to Ingrid and I sort of stepping over each other to talk because we're both pretty excited about this this field. It's an interesting challenge because when we talk about health information, the law doesn't differentiate between, the chiropractic information, dental information, or an AIDS clinic. And it's an important element to kind of get our heads around because, we've taught many individuals and no one would argue that someone's HIV status would absolutely be confidential. But in our travels and in our teaching, a lot of other health professionals doubt whether or not, a cavity, for example, for a dentist, or maybe someone's posture, or whatever element they've got, that should be as restricted as someone's HIV status. Well, in fact, legislation doesn't make the distinction, nor does it leave it in the hands of the custodian or the affiliate. If you've got diagnostic treatment and care information connected to an individual, that in fact is health information and deserves the highest level of your attention and concern. So I kind of want to make that point early because, you know, as Jeff mentioned, we've taught so many health professionals, we've taught so many staff, and that's an important concept. So as you're going through this, we can't have the thinking that, well, it's information that really no one's going to care if it gets out, because that's not the way the law looks at it. And actually, that's not the way most patients will look at it either, from what we've learned.
Yeah, and that extends to things like on your website. Sometimes people have actually pictures of patients. And then now they've made the correlation, oh, that patient now goes to this chiro. So those correlations can be made, and that is technically health information.
Yeah.
So HIA, I think we're tag teaming on this, and if not, again, I overstepped. So the Health Information Act, of course, it came into force in effect April 2001. So this had a long history, and it started with WellNet in '99, which turned into Netcare, as we all know, in 2001. Well, in order to access this provincial, asset, the government wanted to make sure that we all understood the value of protecting, collecting, using, disclosing, and safeguarding health information. And so that's when, in April 2001, we actually had the Health Information Act introduced to show that and demonstrate that, of course, we're protecting health information. Chiros came in 2011. Lucky guys. So what does that mean? Well, in 2011, even though we all came in 2011, we had an obligation right from 2011 to file PIAs to demonstrate that we are compliant, not just for Netcare, but for how your practice works. So, you know, obviously your HIA covers the diagnostic, treatment, and care, health services, registration, as we discussed. But it also governs and regulates all our access to, guess what, collection, use, and disclosure of health information. So, it's very critical and important to understand that this is well thought out legislation, sometimes a little too aggressive, but in the end, it is for our protection and the privacy and confidentiality, of course, of all our health info.
So, you know, when we look at the requirements of the PIA, there's a number of requirements. And so this is going to be kind of an introduction slide. We're going to spend a lot of time for the rest of this this presentation talking about requirements, obligations, duties, and other words that really affect the profession. So the first and most important element is that, you know, chiropractors are named as custodians for the HIA. So for a long time, from 2001 to 2011, weren't named as custodians. Now, during that period, you still had to adhere to the privacy legislation that affected the clinic. But in 2011, as named custodians, there are now specific obligations and requirements that sort of go from there. Now, you know, the statement in section 8.1 of the HIA is that the custodian must maintain the security of health information. And, you know, what sounds like a very simple statement actually finds itself in many layers. So, for example, must maintain the security also relates to the software that you use in the practice. It also relates to how do you manage where the screen is positioned in your office and can other people read it. It also affects paper files and where you store them and how you lock them. So with the simple statement of the custodian must maintain the security, the impact is huge. And we'll start talking through some of these things so that so that you recognize and really start to recognize where the many locations of health data is. Now, as we saw from the poll earlier, you know, we may be speaking to the converted, and that's totally fine. At the same time, we'll get through this, and then hopefully we can answer your questions that relate to it. But hopefully, there's something here for everybody. So, Ingrid, you know, I know you love talking about PIPEDA and PIPA. I'd hate to take away that joy from you.
It's a true story. It is a bit of a joy. I don't know why I love this stuff. I must be don't go there. I must be crazy. So as mentioned at the beginning, it is a whole new world. I mean, the acronyms alone are enough to sink a ship. So PIPEDA and PIPA. So PIPEDA's Personal Information Protection of Electronic Documents Act, and PIPA is the Alberta legislation, and that's Personal Information Protection Act. So PIPEDA is literally across Canada, and it deals with the private sector. Since Alberta has a similar legislation, equal or greater than PIPEDA, we actually are compelled to follow PIPA rules first. So when you file your PIA, or if you have a breach, guess what? We file it under PIPA because that's the legislation that our privacy commissioner cares about. So for PIPEDA, if we're sending information outside the province, let's say, you will see that it does, PIPEDA could apply because you're collecting, using, or disclosing, my three favorite words, CUD, personal information in the course of, let's say, commercial activity. So then that falls under PIPEDA. So the key to it is in and out of Alberta. Inside, PIPA. So even though it's inherently the same, it is our private sector privacy law, and it triggers things like mandatory breach reporting. It triggers things like, as a business, you actually hold a lot of personal information, such as your HR files. So those types of things are very, very relevant to the privacy commissioner in how you're safeguarding that information, how you're protecting it. Is the information stored in Canada or outside, for example? Because if it's stored in the US, you must notify all people that are affected to say, look, we've got your information stored in the US. So those types of things are under PIPA, and it's very important to be aware of that, because don't forget, you're a business as well.
So I'll talk a little bit about, oh, actually, this is Bill 46. This is up to you, Ingrid.
Oh, Bill 46. Oh,
Yeah.
that came in December 2020. So unbeknownst to a lot of people, and maybe the privacy commissioner is not as keen on Bill 46 because they didn't have a full chance to review and comment before all of a sudden, lo and behold, it was out. But what it did is it triggered the splitting of the colleges and associations, which, as you all know, affects you all too. And then it also really made an increase in breach fines. And these breach fines have gone up to 10K to 200K for an individual, which, you know, is meant to be a lesson not to do it, or not to breach, I guess. And that it also is 50K up to 1 million for an organization. And a chiro clinic would be deemed an organization. And so what it does really is, please make sure your privacy impact assessment, your PIAs, and your information manager agreements are in place, because that will definitely assist in compliance to the Act. And then that also demonstrates you've done your due diligence. And more importantly, make sure all your safeguards are in place to protect health information. And that will, again, reduce, hopefully, I'm not saying all the fines, but it will help reduce, because you demonstrate you've made a reasonable effort.
There's a new bill that's been introduced now at the federal level, which looks like it will be a replacement to PIPEDA. And so this is not something typically that we would spend a lot of time on, and won't today either. But in fact, it was one of the questions that came in before we all met today. And it was with respect to how does the European law start to influence laws elsewhere? And this Consumer Privacy Protection Act is largely informed by what happens with GDPR in Europe. There's a number of elements of this that start with PIPEDA, but I think universally now PIPEDA is quite ancient. In August of 2018, PIPEDA upgraded its breach sections, really in a response to requirements by Europe and by GDPR. Now we're seeing the next step in that, where larger and larger sections of legislation are going to be changed in order to develop a much more stringent Consumer Privacy Protection Act. So what we're going to see is, for example, a new tribunal will be started. I don't know the acronym and how we can shorten that, Ingrid, but PIPSIP doesn't seem to roll off the tongue quite well. So it's the Personal Information and Data Protection Tribunal Act. And it's really by legislation now, there will be a new tribunal that gets set up that can impose significant penalties and fines. This will not have to, this is a special organization that will just be looking at that. It also introduces enhanced consent. And we don't have time to walk through consent and enhanced consent today, but as an element of what's coming, there is going to be more and more requirements in plain language to tell the patient exactly what's happening with their data and requesting specific consent regarding that. Enhanced rights of individuals sort of follows. De-identification, if any of your data is being used for research, some ideas around what de-identification is going to be required, again, with consent. All of these things are kind of rooted in the consent. I think, I've probably gone over that enough. Thanks, Jeff, for moving us forward. So the next big question is, who does the Health Information Act apply to? And there's three large groups of individuals that it specifically names. So custodians, which are again named professions in the HIA, the affiliates who typically work for custodians. So in a clinic, a chiropractor working for another chiropractor or a health professional working for a chiropractor is an affiliate in that clinic. And the third is the information managers. It's wherever that information of that patient is being stored, modified, used. All of those are considered information managers. And we're going to go into some detail now about custodians, affiliates, and information managers. Here are the other custodians. So consider yourselves lucky, I guess, that you're one of the key ones. Interestingly, what's missing there would be the mental health arena. And it seems now kind of like a glaring miss, but I expect those changes are coming, and Ingrid might have some comment on that.
Yeah, no, that clearly you're correct. That seemed to be a bit of an oversight, or they felt that, for example, psychiatrists were caught under Alberta Medical Association. So some were deemed to be caught, but psychologists, you're correct, is a glaring error.
Yeah, so let's talk about what are the responsibilities of many of you on this call. The first is that you have to identify and maintain a record of administrative, technical, and physical safeguards. For many of you, this will be captured in your privacy impact assessment. Now, the privacy impact assessment is specifically named in the HIA as a requirement, but then it's secondarily named here as, it's really one of the obligations that custodians have. Through many of the teaching sessions we've had, it's not a reasonable defense to say you didn't know. The next one is sanctions, and this is an interesting piece of legislation that we don't typically see, where you as a custodian have to enable sanctions on someone who did breach or attempted to breach those safeguards that you've identified, which means that if someone in your clinic is snooping, you have to document sanctions around what that means and what response you took relative to snooping in patient records. The third element is affiliates, and this kind of goes almost without saying, but every affiliate in your clinic has to be aware of those administrative, technical, physical safeguards. So training, in fact, the last couple of decisions that have come out of the Alberta Privacy Commissioner says it's not good enough to just file a privacy impact assessment. If you haven't taken the time to train your team, you actually haven't fulfilled your obligation as a custodian. And again, these are, changing in what the expectations are by the Privacy Commissioner, because, it's not specifically, you wouldn't know that was required, but it absolutely is. Agreements, so whoever is storing your data, whoever is collecting your data, or even people that have come into your office, for example, cleaning staff, you need to have written agreements with all of them. And we're going to show you some of the things that you need to be looking for in today's talk. Assess and review, periodically assess these safeguards. We would suggest annually that you sit down with someone who's knowledgeable about privacy and just go through and say, what's changed? What's changed, for example, in my wireless network expectations? Is it okay to have password as the password? Is that okay? So someone needs to sit with you, someone who's aware of privacy and what's happening, and just make sure that it's up to what would be considered a reasonable standard for your clinic. And finally, you have to have a privacy officer. And our recommendation is that it not be the custodian, that you need someone else, because the custodian, the person who's operating the clinic, in most cases is a professional that has a pretty busy schedule. The privacy officer is almost, it's a role unto itself. And expect, for example, that if your patients are asking about your privacy policies, you do not want to be taken out of your treatment room to meet with the patient to talk about privacy policies. So better to have someone who's really dedicated to that role and who can, at a moment's notice, meet with a patient, meet with someone else who's interested in your privacy policies.
So affiliates.
I'm tired, Ingrid. Oh.
Yeah, I know it's a tough job, but someone's got to do it. Anyway, so affiliates. So that being said, like those are all true stories, and we've seen many times where we've come across an affiliate, including at Alberta Health Services, somebody that is actually breached or created an issue. So don't forget that all these affiliates need the training for this purpose, because they collect, use, and disclose information on your behalf. As a custodian, they work for you. They have an onus to protect that health information just as you do. That being said, let's say that you're a custodian, and you have 3 other chiros in your clinic with you. Guess what? They become an affiliate under you. Things like your staff, employed or contracted by yourself, that again, they become an affiliate. Volunteers and students, information managers, all become affiliates. But the key to all this is that if let's just pretend there's a breach, which should never happen, but let's say there was one, and it's a staff that maybe is going in and looking at this information maliciously. Maybe they are, maybe they're not. Well, now, if it's a malicious act, of course, that puts it in a slightly different light. But what will happen is you as a custodian will have to demonstrate that, yes, I trained my staff. Yes, they've had all this. Yes, they signed a confidentiality agreement. Yes, yes, yes. Because if you can't demonstrate that, you are equally liable for their actions. So it's very important that these affiliates get that level of training that you're providing, or that you should be providing. Information managers, this is I shouldn't say a laundry list, but it's a bit of a laundry list of people. So your billing agents, let's say, a billing submitter, shredding companies, which often create a whole new issue because they're like, we're just shredding this stuff. But it's health information that they're destroying. So they must have an information manager agreement. Your IT service provider, absolutely. They are really in the thick of things, and they could see access information. So they need that information manager agreement to demonstrate that they will protect and safeguard information, and they will not disclose anything they may or may not see. Transcriptionists, I don't think there'll be many of those. Your EMR vendor or your Chiro vendor, Jane, Chiro Suite, all of those need to have an actual information manager agreement. Our issue, as we've come across countless times, is that let's say you have a provider from the States. Well, the problem with the US is they're under HIPAA. They have a business associate agreement, a BAA, and they're sitting there, we don't want an IMA. What is an IMA, Very complex. A BAA is missing components that an information manager agreement must contain, and it won't be acceptable to the privacy commissioner. So we need to go through this when we're discussing it. So this is why we say, like, what does compliance mean? It's not just as easy as I filed a PIA. Well, hip, hip, hooray, you've got step one. Wonderful. What it really means is that your clinic and all your vendors will provide and protect that patient data as if it was their own. It needs that due diligence, of course, all those agreements in place, the security in place, and your privacy in place. Because just because you're secure, let's say with your IT or your vendor, that does not mean that your staff don't understand that, oh, I've got the key to the EMR or to the Chiro suite, let's say, I can just go in there and look. Absolutely not. So it's very important to get this compliance piece down right.
Just a quick comment on that. Ingrid, I think one of the things that it's, from a legal perspective, what these agreements do, and these are, in the bundle of information manager agreements. What the law does is it puts a whole bunch of obligations on the custodian. What these agreements do is they transfer some of that liability to Chiro Suite, to Jane, to Shred-it. And I'll give you an example. If it turns out that something in Chiro Suite allowed that information to be vulnerable, that they hadn't done their job as Chiro Suite, even though the patient who lost data will potentially sue you, or you receive a fine, you can hold up that information manager agreement as a shield and say, listen, we did our duty. We're not software developers, but we do have the agreement with Chiro Suite that said if something goes wrong with that software, that they in fact are liable. And that's the value of having those information manager agreements. Like the screen says, any organization that processes, stores, retrieves, or disposes of patient health information, and lots of terrible examples of people throwing away paper files. Well, you should have had that agreement with the company that was in charge of disposing it, because now they're the ones that are in fact liable. Largely this is going to be IT services. The computer fixers, the organizations that have software that stores information, and it's important for them to comply with regulations that are, compliant with the Alberta regulations. So this is where we often get into a debate with, clinics that are using software that originates in the US and that doesn't have a Canadian office. Well, all fine and good. The challenge really, though, is that that risk is then at some level assumed by you as the custodian, because they have not met the basic requirements of the information manager agreement.
Yeah, and that is all laid out in the Health Information Act and in the regulations. So the regulations say exactly what must be in that information manager agreement. And again, BAAs in the US and even some service agreements don't go to that level of rigor. And then again, that liability falls back to the custodian.
Well, let's talk a little bit about compliance and risks to patients. And this is, and Ingrid, you and I have had this discussion quite a bit, which is one of the important elements in breach reporting. And Ingrid will go over this in a bit, but if you're going to report a breach, you have to determine, was there a risk of harm to the patient with that breach? And in fact, it's a bit of an unfair challenge to the custodians, because the custodian has to say, well, I don't think there's a risk of harm. Well, it's not quite that simple. So here's the laundry list of things that you need to think about when you're considering whether or not a breach has led to a risk. So first of all, identity theft. Lots and lots of examples around patients losing information for one reason or another from a clinic. Records are worth about $150 per record. And just as a comparison, credit card numbers are worth less than $5 because guess what? You can cancel the credit card, no big. But patient records are worth $150 because they have detailed personal identifiable information in them. And rather than canceling a credit card, you're now looking at someone potentially applying for a loan in your name. So, so here's the things that are on the list: identity theft, bodily harm, humiliation is a very large bucket. So would it be humiliating for a person's HIV status to be released? Well, potentially very humiliating. It might lead to loss of employment depending on that employer. Financial loss for that patient. Damage to reputation or relationships. Again, another very big umbrella through which lawyers drive a bus through. Business or professional opportunities. Have you lost business or professional opportunities because your health data was leaked? Damage or loss of property and negative effects on credit record. Now, we can give you examples for each one of those. We don't have time for that today, but these are real causes of action that that patients will chase if they feel like one of these has happened.
Well, and it's especially notable in things like with the internet today. If it was Google crawled or whatever, and that information was extracted, you just have no idea what web it has now gone to. And it's just such a huge undertaking and an exposure that it's a big risk. And patients do not. They will travel outside their area to go to someone that they know and trust. And this is a case in point of why.
Ingrid, this is part of your favorite thing to talk about. Collect, use, and disclose patient information.
It's true. So I keep saying, if you remember nothing else, remember CUD, and regurgitate that saying over and over and over again. And the reason is because collection, use, and disclosure is the underpinning of almost every legislation in the world. GDPR, business information, banking information, it's all about what you're collecting, using, and disclosing. So in our case, when we're collecting, using, and disclosing patient information, we have to follow the law and the rules. So we need policies in place. Policy book is usually about 80 pages long, plus or minus, but it has policies on passwords. It has policies on confidentiality, on when you administrate or when you add different things like your admin rights on the computer, your role-based access. All of those are in your policies. Things like your procedures. Are you doing training? You attest to doing training annually, for example. You say this is when we have somebody coming in to get their patient file or a husband coming in, these are the steps we take to obtain consent. All of those are in your policies and procedures. And then, of course, you have to demonstrate your protection. How are you safeguarding your EMR? Is it safeguarded? If you've got Billy Bob's most excellent Chiro suite, you know, then can you demonstrate that they're compliant? Because you are only as good as your weakest link. And if that's your weakest link, you're really in trouble. But anyway, we won't go down that road. And then don't forget just even things like the fax machine. And I know, Rohit, you know this story better than I do, but you know, it provides an opportunity for exposure when you return your fax machine.
Yeah, this was an interesting one that an interesting example, because people forget that we're in a hard drive driven world now, and so every fax that you send or receive is actually stored on a hard drive. And so this is where having a great relationship with an IT firm is the right thing to do, because you can rely on them to know how to erase historical files before you return that fax machine or your photocopier back to the lease agent. Because you can imagine if someone was to look back a year or more in your photocopier or your fax machine, they would find lots and lots of examples where we have patient information connected to treatment information or diagnostic information. And so this becomes really, really interesting. The disposal one was interesting, you know, where people will found unshredded documents in a, you know, in a bin, in a garbage bin behind a practice, and lots of examples like this.
Or even the example of the physician that left all his records in his garage because he was closing or leaving his practice. He left them all in the garage, and lo and behold, he up and died. I don't know how that happened, but notwithstanding that, and his wife is left with all these patient records. What do you do? So there's hundreds of examples of what not to do.
Yeah, and so, just again, none of this is intended to scare you, and I don't mean that to be the destination of this, this talk. In fact, it's the opposite. We're trying to do, and it sounds like many of you are compliant anyways on this call, but the importance of it is that it can really impact your practice. Financial penalties for non-compliance, class action lawsuits, and recognizing that training becomes an important thing. I think if it's one thing you want to take away from this, it's collection, use, and disclosure. And how do you walk a patient through almost a life cycle and say, well, how would my staff deal with that information? How do I know when they collected it in a private way? And that ultimately is about training. So make sure that you have some good training resources that are going to assist you in helping your staff come up to speed on these things.
Yeah, and a lot of this, you're absolutely right. It isn't about scaring. It's tips on what not to do or examples we've come across. So it's sort of like, oh, if you see yourself maybe, oh, I'm just going to return my fax machine. Now you know steps to take on what not to do. So yeah, it's not about scaring. That's no fun. I can do that on Halloween or just by showing up.
Next slide, Jeff.
Oh, the privacy principles. We can tag team, but I love this. So
yeah, go ahead. It's all you.
It's back to my favorite: collection, use, and disclosure. So when you collect, use, and disclose, some easy breezy principles to keep in mind are least amount of information. You don't need to provide a plethora of information. You only need to provide what you know or what you need to do your job. A need to know basis. For example, a dentist won't need to know that he saw the chiropractor, but if he's prescribed medication that could have a conflict with some sedation the dentist is providing, then he needs to know that information. So everything's on a need to know basis. Not everybody in the admin needs to know all the treatments that were happening unless it's needed for billing, et cetera, et cetera. So need to know basis. Highest level of anonymity, if you don't need to, if you're collecting how many people had chronic back injury of L3 disc, then you can provide that without providing patient names. So try to keep that to the highest level of anonymity. Legal authority, let's say the RCMP or some, police swing by the office and say, I want the file on such and such. Swing and a miss there, honey. No, not unless you can provide a subpoena, court order, or warrant. Same as coroner's office. If they happen to come, they can provide you the legal authority for them to collect that information. So that's a very important one to know. And same as consent. Consent. If you have consent, that is still a huge assistance if you release anything. Or so legal, let's say you have an insurance company that wants to get the file on a patient, make sure you have the consent of the patient. And many times insurance company will provide that for you, or legal counsel, if they're a lawsuit pending, they will provide you with the patient consent. So those are all important things to keep in mind, and they're the underpinning principles. Is that still me? Because I love collection, use, and
it's all about you, Ingrid.
I told you I'd regurgitate this quite a few times, and lo and behold, I am. So collection, only the information needed. This comes back to those principles, right? Try to collect it directly from the individual unless otherwise authorized. So things like, I've got a personal directive for my mother because I would say she's not of sound mind, but she apparently is. But if they can collect it directly from the individual, absolutely try to get that information. If not, make sure you have the paperwork in place to have it collected from a second party. And examples would also be interpreters or translators, not, you know, English isn't everybody's first language. And then inform the individual why you're collecting this information. So if you're collecting all sorts of information and they're like, well, why are you doing this? I mean, duh, to provide health care, but notwithstanding that, sometimes people may ask because they feel that you're collecting too much information. So just be able to defend what you're collecting. Use is a given, is to provide a health service, right? It can also be used, let's say, to verify eligibility. That should be logical. And then anything else that's defined in the regs. So that's a fairly small list. So you can use it for other purposes, but coroner, for example, but it is a very restrictive list. So if you're providing a health service, use is a given. Disclosure, of course, everybody can request access to their own information because guess what? It is their information. If that's the case, make sure you keep a disclosure log. I recommend often on file so that you know it, a direct correlation to the patient. But more importantly, if there's disclosures to insurance companies or third parties, again, that consent, and then, you know, keep that log or keep that information in the file. Don't forget you can charge a fee for it too. That's always important to me, but anyway. And then disposal, make sure in your PIA or in your documentation that you have that policy that handles all your record retention and deletion, and then make sure that you conform to the regulations for disposal of records. Is PIA you or me?
I think you should take the next slide and then.
Okay, well, a privacy impact assessment. So the acronym PIA, and I know I shouldn't say this, it does stand for pain in the ass as well as privacy impact assessment, because writing one oftentimes feels like just that. I probably shouldn't swear, but anyway, it is a rather exercise in paperwork, admittedly, but it's a documentation that provides some very valuable insights, because you're reviewing and documenting not just the risks, but also how you're doing your practice and how you're doing business, and making sure all of that conforms to the rules and regulations. So yeah, it's not just a document, as they say, but it actually enables you to practice with assurances that you're conforming to the law and that you're safeguarding health information.
And this goes back, sorry, Ingrid, but this goes back to that thinking around, you know, there's lots of policies and procedures that you need to be able to not only document, and those will get documented in your privacy impact assessment, but then you also want to train those to all of your team members. We're not going to go through this in any sort of detail, but here's an example, you know, of part of the policies that you would want. So for example, what is your wireless networking and remote access policy? You know, and again, things that you might not consider as being an important policy end up showing up, because if you do offer your patients who are waiting in the waiting room, if you do offer them wireless networking while they're sitting there, there is absolutely a risk assessment that should connect that to how do you manage that password, how do you manage that network that you're giving them access to, and a whole bunch of other things. So again, not going into any detail today, but you know, this is a laundry list of things that go from the less important to the, you know, how do you manage breach? How do you manage a breach? So it's all of those things to make sure that you've got a good foundation for your clinic.
But it also, things like virtual care. So with the pandemic, we came a little more into a world of virtual care. Now it could be just suggested exercises to alleviate pain in short term, or it could be a variety of things. But as soon as you offer virtual care, you need a policy on how you're securing it, how you're notifying the patient, how you're interacting. So those all come as part and parcel of the policies. And what's very important about that, or in my opinion, is there's the PIAs, don't forget, are twofold. So there's a neck care expedited PIA, which deals with just that neck care component. And those policies and procedures affixed to that are about 10 pages because they deal directly with neck care. Whereas a PIA for your practice actually outlines all these other ones as we listed on how you can access, how you manage virtual care, or even just things like how you're safeguarding the information or your consents or your confidentiality oaths. So keep in mind, there's two kinds of PIAs. We're not talking the easy breezy CoverGirl neck care PIA, because that is just speaking to the neck care. This is the PIA and the practice and policies for your practice. Sorry, I'll stop now.
No, let's talk a little bit about breaches. Ingrid, why don't you kick us off by what constitutes a breach?
Well, there's two elements, as you probably know. So Section 60.1, of course, the Health Information Act, is the best reading material ever if you have nothing better to do. But that is my opinion, of course. So it's loss, unauthorized access to, or disclosure of individually identifying health information. So it could be anything as simple as an employee snooping or accessing information that they're not entitled to access. And this happens hourly on Netcare, but, well, it may be not that bad. And then, you know, like unauthorized access or collection, use, and disclosure, again, very important to keep that in mind and what you cannot do. This constitutes a breach. Is it reportable? You know what? Breach reporting is mandatory. So the answer is yes. The other thing you always is, oh, sorry, go ahead.
No, sorry, I interrupted, Ingrid.
Yeah, the risk of harm is, you can go.
Oh, no, that's exactly where I was going. And maybe we've talked too much together on this, but this is where, you know, item number 2 is risk of harm. Now, again, this is left up to the judgment of the custodian and a really, really challenging analysis of, you know, who's making that assessment. Well, that's where you go back to that list of how likely. I can tell you, if you read, you know, the riveting accounts of the Privacy Commissioner of Alberta, I'm always surprised at how little it takes for them to consider the risk of harm to be significant. There was one recent judgment where the information of 5 patients was leaked from a medical clinic. Now, all of us sitting here, out of 2,000 patients that are at the clinic, you would say, well, what's the risk of harm? That's not the way the Privacy Commissioner looked at it. They said, what's the risk of harm to the individual? Not to the practice, not how big was the breach, but is there a risk of harm to that individual? And they came, for those 5 that were released, there is a significant fine that was imposed because it was critical information.
Yeah, and that's a very true story. And that risk of harm, the Privacy Commissioner will always default to report, because they will make that determination if they feel that risk of harm. So even though we may make that determination, that risk of harm, it means different things to different people. So the bottom line is, they want you to report all.
You know, when we're looking at examples of breaches, we've got lots and lots of cases around this. And, you know, I think this is just meant to give you a bit of a quick overview. You know, misplaced laptop, misplaced cell phones, a hard drive goes missing. A lot of our customers, before we start working with them, they take the backup drive home. And that goes missing because a purse got lost or because someone stole it from their car. Unauthorized access or use of medical records, chiro records, and this is in many cases a snooping issue where staff are curious about a patient that just walked in. Disclosing through, you know, the real world of gossiping or a misdirected fax or an email. Those are all breaches. And then cybercrime, and we're going to spend a few slides talking about that. I think, Ingrid, in the next slide, yeah, you're going to talk a little bit about these steps because it's not altogether clear. So I'll leave it at that. I know it's clear to you, so you go through it.
Yeah, so the truth is, having a breach is not the end of the world, but what do you do when that happens? So it's really, I'm not going to say easy breezy steps, but there are 4 major steps. You contain the breach immediately. Don't think twice, don't do anything. Stop the flow. If it's, let's say, a laptop theft, try and notify immediately so that IT can maybe, if you have LoJack or a system that will stop the information or wipe the hard drive or enable stopping the access, wonderful. So contain the breach. Easy, right? Sure, not. Assess. You have to immediately assess if there's a risk of harm. And again, that risk of harm is, all over the map. And maybe determine what the possible harms might be. And that could be embarrassment, loss of information. And you might think, oh, you know what, that doesn't sound too bad. But then, run it by, I'm not going to say us, but run it by somebody to say, well, this is what I think. What do you think? Because you may see it as low, they may see it as high. Do an honest assessment. And there's tools out there to enable that. Notification. So the notification in the access as soon as possible. That may be 24 hours later, but that may be 2 hours later. So as soon as you possibly can, the Privacy Commissioner, the Minister of Health, and all the affected individuals. We had one case where the email, they used Gmail and their Gmail got hacked. And they had the duty to inform 7,000 patients. Like that's not an overnight task. So that's a huge thing, and that's why prevention of breaches is so critical. And then all those forms are on the OIPC website, as well as mitigation and remediation. So prevent this from happening again. Make sure your policies are clear and up to date. Go through. I recommend do another full set of training if it was staff, let's say, that breach, because then again, you're taking steps to mitigate any future breaches from happening. So I think it's easy, but hey, my opinion. It's not easy, but let's try to prevent it because nobody wants the fines and nobody wants to go through all the steps to sort of undo something that could have been just a simple mistake.
So I'm going to take a couple of minutes and just talk about some of the cyber threats. I think we're getting behind time, so I'm going to jump through a couple of these slides because there's lots of questions that are probably better or time better spent on those questions. So first of all, ransomware. Many people now are more familiar with it than they were 2 years ago. But basically, it's something that's going to take a hold of your clinic's patients' records, and what they do is they lock up that system, and basically don't give you access to the patient's information or anything in around your clinic. It's fully encrypted and fully locked down until you pay that ransom. And so in Alberta, the typical ransom that we've heard is between $6,000 and $60,000, depending on how many records they were able to get. There's lots of statistics that will just tell you about how prevalent this is. We know about 12 clinics in Alberta that have been hit, including one that I think has ended up shutting down because they couldn't recover from this. We do know that in most cases, or in many cases, that somebody has paid the ransom, and about 20% of the time don't get their data back even after paying the ransom. So let's go to the next slide. Yeah, some more crazy statistics. The important one about that is that healthcare is the target for ransomware. So if you haven't been hit, or if your staff hasn't been hit, consider yourself lucky. Most of the time, it's through email that gets masqueraded one way or another. Here's some examples. Here's an example of things that are coming from Amazon, and through the pandemic, Amazon shows up more often than ever. And so this is a completely fake thing, which says, and there's a great offer, which is, hey, a refund. Well, you're talking to my soul now, right? I want that refund. So they're hoping that whoever's filling this out is caught in the middle of their day. They said, hey, you were double charged for your last order. Let me give you back some information, or let me give you back some money. They've even got a reference code. That's got to be legit. Well, click here to update your access address. That's perfect. It's not like you're asking for a password. Well, as soon as that was clicked, it downloaded the ransomware in the background, and it started to encrypt their entire clinic's files. Next slide. Here's one that I like to talk about. You know, it's a little bit of an older one that came to me in one of my, you know, spam mails, but I use it because people sometimes think that fax or e-fax is secure. So, you know, there's lots of clues on this one. This was one that was much easier to detect, which was, you know, first of all, I didn't know anybody in that area code that would fax me. You can see there's a malformation, you know, this open bracket. Most companies like eFax that are legit would never see that be sent. You see a malformation right at the end. And then if you look at that link, it says, you know, visit the link below to view your fax in Microsoft Word. So now there's lots of stuff that doesn't make sense. You know, I'm not going to view my fax in Microsoft Word. And then I look at that link, and they did not do a very good job of obscuring it. It's like, what? Okay, clearly this is not the truth. So I did not click on that one. There's also some interesting things around social engineering. And so again, this is an older slide where, you know, there's a fraudulent credit card charge from your company. And you can imagine your front desk staff being concerned that, you know, something happened and the clinic is feeling, you know, I have a $749 charge on my credit card from your company. The front desk staff wanting to respond diligently and dutifully, you know, let me make sure that I contact this patient. And then they have a Word doc there that looks like I should click on it, which is like statement.doc. Well, this is an older vulnerability that was known in Microsoft Word. When they clicked on that, that actually initiated the ransomware and locked up. In this case, it wasn't a clinic; it just locked up that company. Next slide. Clinic safeguards. Ingrid.
On it. So clinic safeguards, and I'm going to try and be quicker talker than I usually, no, that's impossible. So clinic safeguards, as mentioned before.
Oh.
Administrative, technical, and physical are the three clinic safeguards that everybody must adhere to. So
I think, Ingrid, your audio might be lagging behind your video. I will take over for the moment until you come back. So there are three large groups of safeguards: administrative, physical, and technical. Administrative is, you know, all of the people, the computers, the telecommunication system, all of that, and how you
yourselves. Sorry.
Nope, you were frozen for a bit, so I'll let you take over here at physical.
Oh, good. It's probably bad to be frozen, but anyway. So physical access, such as, you know, don't use Wi-Fi at Tim Hortons or Starbucks. It's, you know, it's unsecured. You don't need that risk. Make sure you have restricted access to the storage rooms or your files. And, you know, technical, of course, make sure your access is each individual has their own password. We had a breach where somebody was fired and their password was admin and their username was admin. So after they got fired, she went in there and was maliciously destroying some of the clinic files because she had access, and it took forever to try and figure out where the breach was because everybody had the same password. So unique passwords and controls are essential. And make sure to close that off when they leave or anybody leaves.
Next slide, Jeff.
Oh, how long does it take to crack your password? So my rule is long and strong. Doesn't sound good, but true story. So a longer password, you can see, takes longer to crack. If you have upper lowercase and you have symbols in it, again, it's not something that is just easy breezy cover girl. So if you have 3 characters, obviously I can crack that in a heartbeat because it's probably dog or cat or anyway, I'm just kidding. Some people use their initials as their password. Like, it doesn't take long to crack those. So critical to have a long and strong password, and it just demonstrates again adherence to your your safeguards.
And finally, you know, just I think this is probably one of the last slides here. It's important, as I think Ingrid mentioned earlier, we're finding patients asking about it more often. And so, you know, compliance is good for business, not just because of the fines, but it's really important in terms of making sure that your patients feel safe, that you're not vulnerable to these threats that are a part of it, that you've got their information manager agreements that are going to transfer the liability to other organizations when you can. And like I said, you know, there's a reputational damage for your business if in fact there is a breach. We often deal with clinics that have had a breach, and it's very difficult, you know, because you've got to talk to your patient and tell them that their data has gone missing, and here's what the clinic now has to do to make sure that that information isn't used improperly. And those are difficult discussions to have, depending on the clinic and depending on your relationship with that patient. So Jeff, you know, I know you've got a couple of slides, and then maybe we can talk about some of these questions.
Yeah, thanks. And great. I think we covered everything there, so that's good. We do have a number of questions. Before we get into that, one of the questions was asking if this presentation is going to be recorded. It is. We will send out the recording tomorrow to everybody who's registered. So that will be showing up. We also have a number of other resources that you can look into to learn more about privacy. So we have a podcast that we launched. There's 9 episodes that evaluate privacy breaches that have happened at clinics and clinical environments. Talk about why it's a problem, how it happened, and what should have been done to avoid it, and what needs to be done after the fact. We've also done a number of other privacy webinars. We talk about, you know, what changes with COVID-19, how do you do privacy mandatory breach reporting? What does that mean for you? All those kinds of changes and other aspects of privacy. We've got those recorded. They're on our website. If you look under the privacy consulting tab at brightsquid.com, you can find some of those. And we will be sending out a couple of them as well. The other resources that will be coming your way. So we talked a little bit about this. So we've put together a risk of harm checklist that we share with our subscribers. So you'll get that. That'll help you. You know, if you do unfortunately suffer a breach, you'll need to go through these steps to identify if there is a risk of harm. Like we talked about, you know, the different risks to patients, to know if you need to report this breach. With that comes the privacy officer duties. So if you're a privacy officer in a clinic, just as a framework to understand, here's the types of things they should be doing on a daily, monthly, or annual basis. And we will also send you a privacy risk assessment checklist, which is really a checklist to help you understand whether or not you've got all the proper things in place. So it's a pretty extensive document that our privacy team has put together to help you, you know, sort of see the areas that you need to address in your clinic. So that brings us there. Before we dive really into the questions, I'm just going to launch our last poll question. And we're going to just check in again and see how confident we are now that our clinics are compliant. So we'll take, you know, about 30 or 40 seconds to address this and see where we're sitting now. So we've got a number of questions coming in. Or a number of answers coming in. So we do have some questions we'll get to. Just in about another 15 seconds, we'll say, let people think about this a little bit more. So while we're doing that, I'm gonna pull up our questions from previous, and we'll we'll get to that. So that's great. So we've got about half, so less people voting this time, so maybe some shyness around that. But so we'll close the poll, we'll share the results. So a bit of a change. We've shifted down a little bit, but still a lot of confidence. So clearly a lot of people have had their PIAs submitted. And we'll talk a little bit about that more too. But let's get into some questions. So, you know, I think the first question that's come in is pretty quick. If a patient signs a legal document to give permission to use their pictures or video on your web or social media, can you use their pictures?
You can, and so that's a great exercise if you intend to publicize those pictures, make sure that you've got consent. My only caution around it, and this is based on what I'm seeing coming from, you know, legislation, is you don't want that clause buried in a 6-page agreement, right? Have a 1-pager and says, I consent to the use of this of this image or these images for the use on the website or another promotional material. Having it on 1 page, making sure that it's very clear and very restricted, not a blanket, you know, clause that's in a whole bunch of other disclosures, is going to be important and judged. And so absolutely, you should be using your patients in that kind of publicity if it works for you. But just make sure you do have their consent, and then that's, you know, very clear for that patient what you're going to do with that information.
Yeah, and I also recommend, oh, sorry, if you're using a name, try to use the first name and last initial maybe, as opposed to put the full both names. It just lessens, again, the liability.
Yeah.
Can you please clarify what this closure log should look like and how it should be stored?
Yeah, it needs date, information released, name released to, consent obtained, and then the descriptor in the middle. And so there's logs available. I would say email, but there's logs available, but that's the critical thing, is date, information about what was released, who it was released to, was consent obtained, and purpose. So insurance, legal, you know, that type of thing should be all in your disclosure log.
Right. And here we go. What policies would you recommend for affiliates accessing schedules from personal devices?
Accessing schedules from personal devices. So my recommendation around that would be to have a pretty comprehensive personal device security protocol. And that would be not just schedules, but for any other information, including email and other things. Most modern smartphones will allow you to encrypt that data and put it behind some sort of a password, which would be a good start to any personal device usage in the clinic. I know we have clinics that bring their own laptops, or the laptop ends up going home with an individual, and within that laptop there's patient information or even patient emails or whatever. Make sure that you have a comprehensive, you know, personal device policy that's going to very clearly articulate what your minimum requirements are for the use of those products.
Yeah. A couple more questions just to kind of elaborate, sorry, on the social media point. Talking about releasing testimonials and patient photos, as well as, you know, videos of patients sharing their own story in the form of testimonials. I assume we'd put that under the same sort of consent framework as sort of general photo sharing.
Yeah, I think that, you know, again, the narrower you can make that consent. So for example, if it's a produced video or a professional picture, you know, it's okay for that consent to be, you know, I authorize these pictures or this video for the use in these scenarios. The more narrow it is, the more defensible it is.
Yeah, and in that sense, I would add, you know.
Go ahead, Ingrid.
And make those timelines as well. Don't make it an open-ended agreement. In the consent, please state that we will utilize this. And also, I would highly recommend a clause in there indicating that once it's posted on that website, you cannot control who takes it off the website. that you are using it for this purpose and it's limited, but you obviously can't control if somebody takes a picture of it or utilizes that image elsewhere.
Yeah, so here's a question. And I mean, we covered this, but it's specific. So what types of changes in practice would require a PIA, and what is the process and the average cost to create a PIA?
So Ingrid, maybe you take this and I'll plug in where.
So changes that trigger a PIA is changing your electronic vendor, changes to your IT, and changes to your practice that are substantive enough, such as bringing on neck care or appointment reminders or things like anything that would interface with how you're collecting, using, and disclosing health information. Those all trigger a PIA. There's a lot more, but that's the short list.
Yeah, go ahead, Jeff.
Well, I was just going to say, I think, you know, I know from the chiropractor perspective, I know there was some discussion and thought, you know, back in in 2011, when chiropractors became custodians, that there was a grandfathering in of chiropractors in regards to submitting a PIA. Can you talk about that, Ingrid, and what the realities of that are now?
Oh, I love that one. So you're correct. At the initial onset, there was a grandfathering clause. And what that did is it allowed people that were practicing at the time that they did not need to file a PIA right away. However, since 2011, I would be shocked if nobody changed anything that would trigger a change to health information collection, use, or disclosure. A simple example being your electronic records would have improved or changed, or maybe now you're collecting more information to do your job, or you're adding video, or you're adding, you know, secure mail. Any of those things would say that grandfathering is past. So that grandfathering is wonderful for a year or two, but that just gives you the opportunity to sort of get it all together and file a PIA down the road.
Yeah. Anything else to add to that, Robert?
Just, you know, I think the question was, how much does it cost? We've seen prices all over the place. That sort of depends on the profession. It depends on the complexity of the clinic. You know, some of our dental companies or practices have diagnostic image within the clinic. Those are going to be more complicated because of the use of those products. I would say, you know, anywhere in the range of, for a medical clinic, I've seen as low as $1,200, $1,500. In the dental clinics, we've seen as high as $5,000, $7,000, depending on the complexity. I'd say most chiropractors should be under the $2,000 range.
Yeah, and I would agree. I would exercise a degree of caution. I've been doing this for a few thousand years, or feels like. I've seen clinics that have paid upward of 11 to 15K for a PIA, when indeed that is not the level of rigor that was required to do that product. I highly recommend looking, don't jump at the first one that says we do PIAs, because you know, please be careful. You would shop for anything. Don't be different about this.
Yeah. It's sort of, you get going along those lines, we kind of answered that. Yeah, there's some about cost of PIA, so that answers that. Looking at applications, so what about things like Jane apps? So talking about EHR systems, Jane, anything that's cloud-based. Can you talk about that? I mean, there's IMAs obviously considered, but what sort of things should people do to assess those kinds of applications?
Yeah, most of those assessments are probably beyond, you know, a typical individual. So for example, when we're working with a clinic, we're really interested in the data flow and data storage of that very specific application. So Jane's going to have a very different approach than ChiroSuite is, for example. So we make it our jobs, or whoever's writing your PIA ought to make it their job to understand what's the data flow and where are the vulnerabilities of that data. Because when I'm writing the information managers agreement, or when any of you are, you're going to want to say, okay, here's the data flow and here's what you're agreeing to keep safe. And so I think there was another question just around templated IMAs. You might be able to find an information manager agreement that's standard and templated. In fact, there may even be one. I don't know if they've taken it down, but the Alberta Medical Association may have signed something or sent off something. I don't know if they do anymore. But,
that has been taken down because it's so unique. Not that you can have a template to start, but then the schedules explaining what the supplier does, it varies. And same as liability and dual indemnification or single-sided indemnification. So there's a lot of clauses in there that are very unique. That coupled with the fact that there's all sorts of agreements, information sharing. So there's ISAs, IMAs. Well, the Health Information Act mandates the information manager agreement. So there's a lot of confusion around it. So I've noticed that a lot are taking it down because there's inaccuracies. So
yeah, and it also kind of, unfortunately, almost puts them in a position where they've got a template, and no matter how many people are told to modify it, it almost puts the association a bit in a liability position, you know, where they're saying this is the great IMA. Well, it may or may not be, because it's bound to be a little too generic to be effective.
Yeah, that's good. That was a good one to reference there. And you know, I think we've got a lot of discussion around social media posting, that sort of thing. You know, can a person, not a doctor, who has been given access to private medical information, publish that information online? So I mean, you know, I don't know. I mean, we could be talking about anybody in this case, but you know, I think really in the clinical environment, we're looking at staff and affiliates or in that realm. You know, hopefully the answer no is fairly clear.
Yeah, it's a hard no.
Yeah.
No, obviously
Yeah,
you can't control. Let's say somebody in the waiting room posts a social media post. Now, some of that can't be controlled, but that's where the value of having your staff understand you don't discuss patient information at the front counter where every Tom, Dick, and Harry can hear. It's the last thing you need. So try to keep those medical conversations private.
Yeah. And I mean, there's a great example, Ingrid, we talk about in our larger privacy training that we do for the clinics that we work with. You know, the woman who looked up every female member of the church on Netcare to find out who was on birth control and publish that on Facebook.
Those are outrageous. I mean, you know, I think that the chances of that happening are so much smaller than the reality of someone in your clinic being curious around the other people in your clinic and then wanting to share that information. So privacy training, privacy training, privacy training. There was another question that I saw come up around, you know, what if the pictures aren't, the faces are not visible of the individuals? Is it okay to publish that information? And the answer typically is going to be depends. You know, if they've got a big, you know, lapel that particularly identifies them because it's of a certain, you know, club, or it's their name or something else, and they can be, even if the face is obscured, they could reasonably connect that to to that patient. You know, again, it starts to get down the road of boy, you know, as soon as someone through very heroic means can identify that patient, it's probably a problem. Now, if they can't, if it's very deliberate and everybody's backs are turned and you can't tell and blah, 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 then it's probably okay. So it's a judgment call. It's one of those.
Yeah.
Yeah. We have a couple more questions on PIAs. One we've addressed a little bit, but what are some of the requirements specifically around PIAs for chiropractic? Is there anything different about a PIA from a chiropractor standpoint versus a dentist or a doctor or a dental hygienist or anything else?
So other than the fact that they have to file one, or from a perspective of how it's written? So it is very much association or discipline driven. For example, dental ones run into hundreds of pages, and they deal with all sorts of idiosyncrasies, whereas chiros and medical tend to be very specific to your practice. So templating, as a matter of fact, Alberta Health and the OIPC just cringe when they hear that there's a template out there for this, because that's not beneficial. You're not then writing about your practice. So yes, they are quite unique. Admittedly, chiropractors operate generally the same way as other chiropractors. That is a benefit, but a lot of things you wouldn't need all the policies, let's say, that a dentist does, because they're a pay for service and they operate different and they deal with insurance, same as chiros do, but different again than medical. So yeah, sadly, there's too many off. And then the biggest thing, and one of the biggest mistakes everywhere, is that a lot of them think they file a neck care PIA and they're done. But that neck care PIA is just about neck care. And your secondary thing to consider, it's not a one and done. PIAs are a living, breathing document about how your practice moves and evolves. And that's why that periodic review. And I'm not saying that because I love privacy.
Jeff, I know that we've only got 5 minutes left. We've got lots of questions. Let's rapid fire them now.
Yeah, so the other big question is about email use. Can we talk about using email, even like with or without patient consent, to transmit patient data?
So there's a lot of misunderstanding around this. There's a sense that if people had patient consent, that it would be fine. In reality, in order to get that consent, you have to make it very clear what the concern is with that. And so I'll give you an example. This clinic that lost 7,000 patients' emails. The real consequence of losing that might be that now patient, your information, your private health information might become available to hackers that are going to steal your identity. So if you're willing to have those discussions, then you can get informed consent. It's not good enough to say, hey, can I have your email? Great, check the box. No. You have to be very clear about what the consequences are and potential consequences are of losing that information. That clinic that lost those 5,000 or 7,000 email addresses could have never prepared those patients for that.
Yeah, it's about the risk, and the risk of email not a secured email product is too large.
Yeah. So
that was a big one. Signed picture that patients provide, like if it's an athlete that's coming to the clinic for treatment, this is obviously a big consideration for chiro physio.
Perfect. If the patient's giving you their picture, it's consent.
Yep. And can we talk about, so if the clinic has a breach, who's liable? Like when we look at custodian, affiliates, how does that work?
Custodian. Affiliates act under the governance of the custodian. If the affiliate has misappropriated or done things that are illegal or whatever, it's on the custodian, and that's where training becomes super important. Sanctions become important. Regular policy review becomes important.
Yeah.
And then can we talk about appointment reminders via text and other ways?
Text is loosey-goosey.
Yeah, it's the way it's kind of looked at is minimum information. Like it's okay to say appointment time and appointment date without any other details. So things like, make sure you take your Advil before coming, can't say it. So it has to be the most generic information. And candidly, the advice we give to a fertility clinic is don't use even the clinic's name, because it's sensitive information. So even the clinic name becomes very interesting. But for most clinics, it's okay to use the clinic's name.
And then there's one last question. I mean, we've addressed pretty much all of them. The last question I've kind of been putting off is, do we recommend third parties for like PA consultants or any of them? I mean, there's us, obviously. There's a handful of other people in the province that do them. It's just a question of kind of finding them.
Yeah, I wouldn't almost trust us because we're conflicted there. We do that type of work, but maybe work with Parker. Maybe work with Parker, and Parker will put together a list. I don't know, but we're conflicted, so we'd be the wrong people to ask.
And I know, Parker, you talked about you might want to chime in here, but you talked about kind of work happening on your end. So I don't know if you want to talk about that.
I was just going to jump in and say that, first of all, I failed to mention this at the front end. Brightsquid is actually a consultant. They had offered to provide this information to us under no obligation that either the association or like the ACAC or any chiropractors would feel bound that they would have to use or go to see Brightsquid or anybody else. There are a number of organizations and entities that do this information. There is a listing on the website for the Office of Information and Privacy Commissioner. There are other different lists that are floating about there. This is something that we will be looking at putting together again as the association continues to move forward as part of the separation from the Bill 46. In the meantime and in between time, if you have questions, you can certainly contact me directly.
Thank you, Parker.
Great. Thanks, Parker. Well, that brings us to the end of our time, and thanks everyone for your attention today, and Rohit and Ingrid and Parker, thanks for your participation. You will get a quick survey pop up when we finish this. This is helpful for Parker and his team, as well as for us to know if there's anything else we can do to make these things better. So really appreciate your time. Thanks for tuning in today. We will send out the recording tomorrow. Have a great day, everybody. Thanks so much.
Bye now.
Thank you so much. Cheers.
Thank you.